friend, how are you? I'm Advocate Gaurav KUMAR GUPTA. I am Chartered Accountant and MBA Finance and PhD holder. My project डेरिवेटिव मार्केट फ्यूचर ट्रेंड एनालिसिस। आज हम टॉपिक डिस्कस कर रहे हैं आर्बिट्रेशन के बारे में डिस्कस कर रहे हैं। आर्बिट्रेशन में स्टेटमेंट ऑब्जेक्ट एंड रीजन क्या होता है? आर्बिट्रेशन का स्टेटमेंट ऑफ ऑब्जेक्ट एंड रीजन क्या होता है? The law on arbitration in India is at the present the substantially contained in three enactments, namely the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, and the Foreign Award Recognition and Enforcement Act 1961. It is widely felt that the 1940 Act, which contained the general law of arbitration, has become outdated. The Law Commission of India, several representative bodies of trade and industry and expert in the field of arbitration have proposed amendment to this act to make it more responsive to contemporary requirement. It is also recognized that our economic reform not be may not become fully effective if the law dealing with settlement of both domestic and international commercial dispute remain out of tune with such reforms like arbitration. Arbitration cancellation is also getting increased worldwide. Recognition recognition as an instrument for settlement of dispute. There is, however, no general law on the subject in India. The United Nations Commission on International Trade Law adopted in 1985 the Model Law of International Commercial Arbitration. The General Assembly of the United Nations has recommended that all countries give due consideration to the said model law in view of the desirability of uniformity of the law of arbitral procedure, the specific needs of international commercial arbitration practice. The UNISTRAL also adopted in 1980 set of conciliation rules. The General Assembly of the United Nations has recommended the use of these rules in case where the dispute arises in the context of international commercial relations and the party seek amicable settlement of their dispute by resources of conciliation. An important feature of the said UNCTR model law, United Nations Commission of International Trade Law model law rule is that they have harmonized concept, arbitration and conciliation of different legal systems of the words and thus contain provision which are designed for universal application. Though the said UNICTRL का फुल फॉर्म है यूनाइटेड नेशनल कमीशन on international trade law rule are intended to deal with international commercial arbitration and conciliation, they could, with appropriate modification, serve as model for legislation on domestic arbitration and conciliation. The present bill seeks to consolidate it and amend the law relating to domestic arbitration, international commercial arbitration, enforcement of foreign arbitral award and to Foreign Arbitral Award and to define the law relating to conciliation, taking into account the said UNCTRL model law and rules. The main object of the bill are as under: to comprehensive cover international and commercial arbitration and conciliation as also domestic arbitration and conciliation, to make provision for an arbitral procedure which is fair, efficient and capable of meeting the need of the specific arbitration, to make the provision for arbitral procedure which is fair, efficient, and capable of meeting the in need of the specific arbitration, to provide that the arbitral tribunal give reasons for its arbitral awards, to ensure that the arbitral tribunal remain within the limit of its jurisdictions to minimize the supervisory role of court in the arbitral process. The permit an arbitral tribunal to use mediation, cancellation, other procedure during the arbitral proceedings to encourage settlement of dispute, to provide that every final arbitral award is enforced in the same manner as if it were a decree of the court, to provide that a settlement agreement reached by the party as a result of cancellation proceeding will have the same status and effect as an arbitral award on agreed term on the substance of the dispute rendered by an arbitral tribunal, and to provide that for purpose of enforcement of foreign awards, every arbitral awards made in a country to which one of the two international conventions relating to foreign arbitral awards to which India is a party apply will be treated as a foreign award. The bill seeks to achieve the above object. The bill received the assent of the President of India on 16 August 1996. Arbitration means होता है any arbitration whether not administered by permanent arbitral institutions. Arbitral agreement means an agreement referred to in section 7. Arbitral award means include a interim awards. Arbitral tribunal means होता है means a sole arbiter, a panel of a panel of arbitrators. Court means of the principal civil court original jurisdiction in a district and including the high court exercise of its ordinary original civil jurisdictions, having a jurisdictions to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit, but does not include any civil court of grade inferior to such principal civil court, any court of a small cause. International commercial arbitration means an arbitration relating to dispute arising out a legal relationship, whether contractual, not considered as commercial under the law in force in India, where at least one of the parties, an individual who is a national of habitually resident in any country other than India, a body corporate which is incorporated in any country other than India, a company, an association, body of individuals who central management control is exercised in any country other than India, the government of a foreign country. Legal representative means a person who in law represents the estate of a deceased person, includes any person who intermediates with the estate of the deceased, and where a party acts in a representative character, the person on whom the estate devolves on the death of the party. So, acting section 2. Arbitration agreement 1 in this part, arbitration agreement means an agreement by a parties to submit to arbitration or certain dispute which may arise between them in respect of defined legal relationship where contractual not. An arbitration agreement may be in the forms of an arbitration clause in a contract in the form of a separate agreement. An arbitration agreement shall be in writing. An arbitration agreement is writing if it is contained in a document signed by the parties, an exchange of letter, telex, telegram, other means of telecommunication which provide a record of the agreement, an exchange of statement of claim before in which an existence of the agreement is alleged means कथित तौर पर on one party not denied by other. The reference in contract to document containing an arbitration clause constitutes an arbitration agreement if the contract is writing and the reference is such to make the arbitration clause part of the contract. Section 7. Power to refer parties to arbitrations where there is an arbitration agreement, a judicial authority before which an action is brought in a matter which is the subject an arbitration agreement shall if parties so apply not later than when submitted his first statement on the substance of the dispute refer the party to arbitration. refer to party to arbitration. The application referred to in subsection 1 shall not be entertained unless it accompanied by original arbitration agreement, a duly certified copy thereof. Notwithstanding that an application has been made under subsection 1 and that the issue is pending before the judicial authority, an arbitration may be commenced, continue, and arbitral award made. Section 8. Composition of arbitral tribunal. Number of arbitrators. The parties are free to determine the number of arbitrators, provided that such number shall not be even number. Filing the determination referred to in subsection 1, the arbitral tribunal shall consist of sole arbitrator. Section 10. Appointment of arbitrator. 1. A person of any nationality may be an arbiter unless otherwise agreed by the party. Subject to subsection 6, the parties are free to agree on a procedure for appointing to arbiter and arbitrator. Arbiters. Filing any agreement referred to in subsection 2 in arbitration with three arbitrators. Each party shall appoint one arbitrator, and the two appointed arbiters shall appoint the third arbitrator, who shall act as the presiding arbitrator. If the appointment procedure in subsection 3 apply and a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so for the other party, the two appointment arbitrator fail to agree on the third arbiter within 30 days from the date of their appointment. The appointment shall be made upon request of a party by the Chief Justice, any person, institution designated by him. Filing any agreement referred to in subsection 2 in arbitration with a sole arbiter, if the party fails to agree on the arbiters within 30 days from receipt of request by one party for the other party to so agree. The appointment shall be made upon request of party by the Chief Justice or as person, institution designated by him, where under an appointment procedure agreed upon by the party, a party fails to act required under that procedure, the two appointed arbiters fail to reach an agreement except of them under that procedure. A person, including an institution, fails to perform any function instrument to his in it under that procedure. A party a party may request the Chief Justice. A party a party may a party may request the Chief Justice, any person, institution designated by him, to take the necessary measure unless the agreement on the appointment procedure provide other means for securing the appointment. A decisions on a matter instrument by subsection 4, subsection 5, and subsection 6, the Chief Justice, the person, institution designated by him, is final. The Chief Justice, the person, institution designated by him in appointing an arbitrator shall have due regard to any qualification required of the arbitrator arbitrator by the agreement of the party. Other considerations are likely to secure appointment of independent and impartial arbitrator. In case of appointment of sole third arbitrator in an international commercial arbitration, the Chief Justice of India, the person, institutions designated by him, may appoint an arbitrator of a nationality other than the nationalities of the parties, where the parties belong to different nationality. The Chief Justice may make such scheme as he may deem appropriate for dealing with matter interested by subsection 4, subsection 5, subsection 6, where more than one request has been made under subsection 4 or subsection 5, subsection 6 to the Chief Justice of different High Court. There designates the Chief Justice, he designates to whom the request has been first made under the relevant subsection shall alone be competent to decide on the request. 12 का है where the matter referred to in subsection 4, 5, 6, 7, 8, 10 arise in an international commercial arbitration, the reference to Chief Justice in those subsections shall be construed as a reference to the Chief Justice of India. Where the matter referred to in subsection 4, 5, 6, 7, 8, and 10 arise in any other arbitration, the reference to Chief Justice in those subsections shall be construed as a reference to the Chief Justice of the High Court within whose local limits the principal civil court referred to in clause E of subsection 1, section 2 is situate, and where the High Court itself the court reference to the clause of the Chief Justice of that High Court section 30. Jurisdictions of arbitral tribunal. Competence of arbitral tribunal to rule of its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, include ruling on any objection with respect to existence or validity of the arbitration agreement and for the purpose. Arbitration agreement are for the purpose. And arbitration clause which form part of contract shall be treated as agreement independent other term of the contract, and a decision by the arbitral tribunal that the contract is null and void shall not initial ipso jure the invalidity of the arbitration clause. A plea that the arbitral a plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed participate in the appointment of an arbitrator. A plea that the arbitral tribunal is exceeding the scope of authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceeding. The arbitral tribunal may, in neither of the cases referred to in subsection 2 and subsection 3, admit a later plea it is if it considers the delay justified. The delay justified. The arbitral tribunal shall decide on a plea reference to in subsection 2 and subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding, make an arbitral award. A party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award in accordance with section 34, section 60. Place of arbitration. The parties are free to agree on a place of arbitration. Second point, filing any agreement referred to in subsection 1, the place of arbitration shall be determined by arbitral tribunal. Arbitral tribunal having regard to the circumstances of the case, including the convenience of the party. Notwithstanding subsection 1, subsection 2, the arbitral tribunal may, unless otherwise agreed by the party, meet at any place is considered appropriate for constitution among its members from hearing witness, expert the party for inspection of document, goods, other property, section 20. Commencement of arbitral proceeding. Unless otherwise agreed by the party, the arbitral proceeding in respect of a particular dispute commence on the date on which request for the dispute to be referred to arbitration is received by the respondent. Language. The party are free to agree upon the language to be used in the arbitral proceeding. Filing any agreement referred to in subsection 1, the arbitral tribunal shall determine in the language to be used in the arbitral proceeding. The agreement of determination, unless otherwise specific, shall apply to any written statement by the party and hearing and any arbitral award decision other communication by the arbitral tribunal. The arbitral tribunal may order that any documentary evidence shall be accompanied by translation into the language agreed upon by the party determined by the arbitral tribunal. Section 21. Statement. It is not incompatible with an arbitration agreement for an arbitral tribunal to encourage settlement of the dispute with the agreement of parties. The arbitral tribunal may use the mediation, conciliation, or other procedure at any time during the arbitral proceeding to encourage the settlement. If during the arbitral proceeding the parties settle the dispute, the arbitral tribunal shall terminate the proceeding if requested by the party and the no object to be arbitral tribunal. Record the statement in the form of an arbitral award on agreement terms. An arbitral award on agreed terms shall be made in accordance with Section 31 shall state that in arbitral award. An arbitral award on agreed terms shall have the same status and effect any other arbitral award to substance of the dispute. Section 30. Form of and content of arbitral award. A arbitral award shall be made in writing and shall signed by the member of arbitral and tribunal. From the purpose of subsection 1 in arbitral proceeding with more than one arbiter, the signatures of majority of all members of the arbitral tribunal shall be sufficient so long as reason for any omitted signature stated. The arbitral award shall stated the reason upon which is based unless the parties have agreed that no reason to be given. The award is an arbitral award on agreed terms under Section 30. The tribunal, the arbitral the arbitral award shall stated that and the place of arbitration as determined in accordance with Section 20 and the award shall deemed to have been made at the place. After the arbitral award is made, a signed copy shall be delivered to each party. The arbitral tribunal may at any time during the arbitral proceeding make an interim arbitral award on any matter with respect to which it may make an final arbitral award unless otherwise agreed by the party, wherein is so far as an arbitral award is so far is for the payment of money. The arbitral tribunal may include in the sum for which award is made the interest at such rate it deems reasonable on the whole any part of the money for the whole any part of the period between the date on which the cause of action arose and the date on which the award is made. A sum directed to be paid by an arbitral award shall, unless the award otherwise directed, carry interest at the rate of 18 percent 80% per annum from the date for award the date of payment unless otherwise agreed by the party. The cost of an arbitration shall be fixed by the arbitral tribunal. The arbitral tribunal shall specify the party entitled to cost, the party who shall pay the cost, the amount of cost method determine that amount and the manner which the cost shall be. अगले वीडियो में हम टर्मिनेशन ऑफ प्रोसीडिंग के बारे में बताएंगे कि टर्मिनेशन प्रोसीडिंग क्या होता है। आज का वीडियो यहीं पे वाइप आउट